employee or employment or an employee of a place of confinement. You understand that charge, sir?
No, could you say it more? Yeah, I understand. But I got the scuff right here. I couldn't hear you there.
Okay. That is a felony, punishable by up to 5 years incarceration, $2,500 fine plus court.
That moment where the judge reads the maximum penalty is not ceremonial, it's legal scaffolding. The bench informs the defendant he faces up to 5 years incarceration and a fine plus court costs. To create an anthrocourt understanding of the stakes, for a self-represented defendant, this does two things. It protects the court from claims later that the defendant didn't know the consequences, and it telegraphs to the jury later the seriousness of the offense. Self-representation, by the way, is a double-edged sword. The court's admonition that it will not treat you better or worse is a neutral warning. But in practice, a pro se defendant risks missing technical defenses, failing to preserve objectionable evidence, or misreading procedural deadlines. Later in the transcript, we'll see how the judge attributes some of the case delays to the defendant's participation issues. If you're watching and thinking about representing yourself, weigh the gravity of a felony against your confidence in navigating court rules. Would you go pro se on a case with 5-year exposure? Say pro se or counsel in the comments.
Do you understand the maximum penalty, sir?
Yes, I do.
All right. And you're electing still to represent yourself?
Yes, I am.
All right. There's great peril in representing yourself. You need to be aware of that. The court won't treat you any better, won't treat you any worse by you representing yourself. I would further advise you that if at any point you wish to be represented by an attorney, then you should let the court know at that point, and I will do my best to arrange that you have an attorney to represent you. You understand that, sir?
I do.
Okay. All right. Are we ready to proceed?
Your Honor, the people are ready to proceed with their preliminary examination, and I did hear Mr. Jolly acknowledge on the record that he does have the police report now that was served, I believe, Thursday night or Friday by jail staff, and I provided the court with a copy of the proof of service. The people are ready to proceed. We intend on calling one witness when the court is ready.
All right. Very good. And I do have the proof of service in the file, and you may proceed then, Mr. Tip.
Thank you, Your Honor. The people would call Officer John Apple to the stand.
Sir, please come forward to be sworn.
You solemnly swear or affirm the testimony you're about to give me the truth and nothing but the truth, have you?
Yes, I do.
Have a seat, state and spell out your name.
Hello, I'm Officer John Apple, J-O-H-N-A-P-P-L-E.
All right, you may inquire.
Thank you, Your Honor. Sir, how are you currently employed?
I work at the Washington County Sheriff's Office and their corrections division.
And how long have you worked in the corrections division of the Washington County Sheriff's Office?
Approximately 18 months.
Okay. Were you working in that capacity of August of last year, 2024, specifically August 10th?
Yes.
Okay. And you were working in the Washington County Jail? Your shift on that time, on that day?
I believe the noon shift is 3 o'clock to 11.
3 p.m. to 11 p.m.? Okay. Directing your attention to around 5 o'clock in the afternoon or early evening on August the 10th, 2024, what were your job duties in the Washington County Jail at that time? What were you doing?
I believe at that time we were doing our meal pass, make sure everyone gets dinner for the night. In the specific housing we were at, it was a door-to-door feeding unit, so you work with a incarcerated individual, worker, or trustee, door-to-door do meal pass.
Okay, and what specific block or area of the jail were you working at that
I was
time?
working at A block that also has our max housing unit and observation unit.
So it has max housing observation unit, and that is within the A block of the jail.
Correct.
Okay. And you said you were passing out dinner effectively?
Correct.
Okay. Are you familiar with an inmate by the name of Cody Jolly?
I am, sir.
Was that individual housed on that block at that time?
He was.
Okay. I don't know, Your Honor, is the screen that in front of Officer Apple the same screen that we're seeing, or is that screen black?
It should be this.
Okay.
Well, no, he is. Yes, he is seeing what we're, I guess, primarily that the one that's moving.
Okay.
Is the one that he's seeing. Right?
Officer Apple, can you identify anyone on the screen in front of you that you recognize from that date of August 10th, 2024?
I can't, sir. I see an incarcerated individual, Cody Jolly.
Okay. And can you describe what they're wearing on the screen so we know who you're talking about?
Orange pants and a white long sleeve t-shirt.
Thank you. Your Honor, may the record reflect identification of defendant Cody Jolly.
Record shall so reflect without objection.
So Mr. Jolly was housed on A block and that's where you were passing out meals on August the 10th of 2024?
Yes, sir.
Okay. What, if anything, occurred when you had an interaction with Mr.
This is the factual core. Officer Apple describes approaching Mr. Jolly's door during meal pass, turning for a beverage, and then being struck in the head and face 3 to 4 closed fist blows above the left eye. Those specifics are gold in a prosecutor's notebook. Why? Because they support probable cause and the violence element of an assault on a corrections employee. Notice also the context: a meal pass in a maximum observation unit, limited staff, and an inmate worker nearby. That means an elevated safety concern if an inmate becomes violent. Apple's testimony that he struck back and stepped fence and immediately radioed for backup demonstrates both the immediacy of the threat and the institutional response. From a defense perspective, you'd need to question provocation, intent, or whether there was a mistaken identity, but Mr. Jolly waived calling witnesses. The judge will use this uncontradicted testimony to evaluate probable cause. For viewers, that level of detail, location of strike, number of hits, and medical follow-up is what makes a judge say bind over later keep. Your ears open for how the judge uses these facts in his legal analysis.
Jolly on that date and time?
When I approached his door and breached his door to pass him his dinner for the night, he asked me if he could have another tray. He was sitting on his bed in the unit at the time. I told him that, if I have any extras, I'll circle back to him. And when I turned to collect the beverage for him, he began to stand up, and I believed that he was coming to approach me to grab his drink. But at that point in time, he began to strike me in my head and face area. We got in a bit of a scuffle. I tried to gain control of Mr. Jolly. He kept delivering strikes to me. So I delivered strikes back in self-defense. Was able to gain control of Mr. Jolly to the point where I could get back to my radio and essentially call for backup. And the jail called an available officer call.
Okay. And I'm going to just unpack that a little bit, Officer Apple. So you passed Mr. Jolly his tray of food,
Right.
and then you had turned to retrieve the beverage from the cart.
Right.
And where was that cart located?
It was just off to my right, so it was almost right in front of his door. I had an inmate worker helping me pass trays at the time, so I turned to him to get the cup. As I faced Mr. Jolly, he began to stand up. Like I said, I believe he was coming to meet me halfway for the beverage, and he began to strike me.
Okay. Other than yourself and the inmate who was assisting you, were there any other corrections officers in that area at that time?
No, sir.
Okay. Did Mr. Jolly say anything to you as he stood up and began, I guess, to kind of advance towards you?
No, sir.
Okay. You said he struck you in your face.
Right.
Do you have any idea approximately how many times?
3 to 4 times.
Okay. Do you recall, was that closed fist, open fist, slap? Can you give us any detail?
Close fit. So it was kind of towards the top left side of my head and my face.
And
Knocked my glasses off.
Okay, so kind of, you said left side of your head, above your eye. Is that a yes?
Yes, sir.
Thank you. After he struck you a few times, you were able to basically strike him back in self-defense and eventually get control over Mr. Jolly. Is that fair to say?
Yes, sir.
Okay. Did other jail staff respond to assist?
Once I got control of Mr. Jolly and was able to get back to my radio, during the scuffle, I got knocked off as well as my glasses. So I was on top of Mr. Jolly at the time, was able to recover my radio and get that call out, and then other officers did respond.
Okay. Did you suffer any sort of injuries from this?
Superficial injuries, bruising, soreness, no long-term surgical anything. I did get sent out to St. Joe's at the time, or the Trinity Health emergency room, and then I had to do a follow-up, make sure I didn't have a concussion or anything before I could return to work.
Okay. And just so we're clear, the Washtenaw County Jail, is that located? I can never get this right. Is that technically in the city of Ann Arbor? No, Pittsfield Township. Okay. In Washtenaw County.
Yes, sir.
Thank you. I have no further questions. All right.
Okay, Mr. Jolly, do you have any questions for Officer Apple?
No, I do not. Not at this time.
You have no questions?
Not at this time. It's pre-trial right now at this time.
All right.
Your Honor, I have no redirect. I have no further witnesses and the people would rest.
All right, you may step down, sir. All right. Mr. Jolly,
When the prosecution rests on a single eyewitness here, a corrections officer, the judge asks whether the people have met the probable cause threshold for binding over. Probable cause doesn't require proof beyond a reasonable doubt. It just requires sufficient facts that a reasonable person would believe an offense occurred and the defendant committed it. That's why documentary detail and credible witness testimony matter so much. The officer's medical follow-up, a visit, concussion check, and contemporaneous radio call strengthen the people's case. The defense's decision to call no witnesses means the record largely stands uncontested. A risky tactic for anyone, but doubly risky for someone representing themselves. Also note the procedural nuance. Preliminary examination is not a trial. It's a threshold hearing to determine whether the matter moves up to circuit court. A lot of viewers confuse that if you don't. You'll better understand why bound over simply means let the higher court sort this out.
do you have any witnesses that you'd like to call?
I do not. Just to remember, this is pre-trial, correct?
Well, it's a preliminary examination, Mr. Jolly.
Okay. All right. I was told it was pre-trial, led to the last court date, and then he told me you were rescheduling it for pre-trial, and so I don't know where we're at in the process. It was my understanding these last two have been pre-trial.
No, they were PCC and then your preliminary examination, sir. And today is your preliminary examination.
Okay, so okay. So what is my next one then?
Well, I don't know yet.
Okay.
Do you have any witnesses that you want to call today?
No, I do not. I just
Okay. Do I have a motion?
So Your Honor, my question was that it's been over a year and I'm just trying to get to pre-trial. And my understanding was that these last two cases were both pre-trial. It's been over a year. And for some reason, we still haven't got the pre-trial yet. Can I ask you why?
Well, I can tell you that you had a competency evaluation that there was an issue with you participating in. And then there was always the issue of your participating in all of the proceedings as they were set. So the matter could not move until there was a motion that was filed by the people, given your reluctance to participate.
Okay, well, that motion was.
So Mr. Jolly, I'm not going to sit there and argue with you. I'm here now with your preliminary examination. You don't have any witnesses. Do I have a motion from the people?
Yes, Your Honor, at this time, people would move to bind the defendant over as charged on the one count before the court.
Mr. Jolly, do you have a response to that?
I didn't hear him. Could you say that one more time?
Pardon?
I didn't hear what he.
Here we see the defendant trying to shift focus to procedure requests for a 12-person jury, a 45-day speedy trial, and questions about his case status. That's a sensible play. Procedural protections can sometimes force case movement or dismissal if delays are attributable to the prosecution. But note the judge's response. Competency evaluations and the defendant's own participation problems caused some of the delays. The practical lesson is this: courts differentiate between delays caused by systemic backlog and delays caused by a defendant's actions or lack of cooperation. If a defendant contributed to the timeline, missed hearings, competency issues, or failure to litigate, the judge will be reluctant to find a speedy trial violation. For people watching, speedy trial claims are technical and context-driven. Filing a motion is just step one. Proving prejudice and attributable delay is the heavy lift. This exchange foreshadows the judge's later ruling that binds the defendant over while preserving his jury trial rights in circuit court.
It's
Your Honor, the people would move to bind the defendant over on the one count before the court and ask this matter proceed to circuit court for further proceedings.
Do you have a response, Mr. Jolly?
So, okay, my response is to move it to circuit court. We're talking about conference then. Is that correct?
Pardon?
Or if we move it over to circuit court, then we're on to conference, is that correct?
On to conference?
Is that, yeah, he just said move it to circuit, does that mean we're on to conference? That was my understanding, is that we're moving to conference. That would also be my request too.
Well, I don't know what you're trying to say. All I know is that what the people have asked is that the matter be bound over to circuit court for you to stand trial there.
Right, which would be moving from here to conference, which is right before trial, correct?
You would have different proceedings before Judge Slay, yes.
Which would probably be conference, am I correct?
Sir, you will have different proceedings before Judge Slay.
Okay.
Do you have anything in response to the people's motion to bind over?
You know, I would prefer, my response is to prefer to move on to conference. That would be my response to that. And then I also have my own, I would like to request again. I put in the motions for jury trial, a 12-person jury trial. And I also put in my motion for the 45-day speedy trial. And I am also requesting those as well again here today. Motions were.
Right. The court has heard the testimony in this case from Officer Apple. The court does believe that the people have indeed sustained their burden of showing that the defendant.
This is the judge's legal conclusion. After hearing Officer Apple's testimony, the court finds the people have established probable cause that the defendant assaulted a corrections employee. Legally, that converts this matter from a preliminary level hearing to a circuit court charge, effectively moving the case from fact-finding to formal criminal prosecution. It's important to understand the consequence. Being bound over is not a conviction. It simply signals that there's enough evidence to proceed to trial in a higher court where discovery, motions, plea bargaining, pretrial conferences, and eventually a jury trial can occur. The judge also formally places the defendant on notice of the charge, the statutory penalties, and the procedural next steps, arraignment and pretrial dates. For Cody, this means the case escalates, his options narrow, and the stakes stay high. If you're a viewer tracking defense options, this is the moment the defense needs to pivot to discovery, preservation of issues for appeal, and trial preparation.
Was in a place of confinement that he also then assaulted an employee of that place of confinement. And so for those reasons, the court would bind the defendant or find that the people have established probable cause that this offense was committed and that the defendant committed it, and the defendant would be bound over to circuit court to stand trial. Jolly, you're now proceeding into what will be your circuit court arraignment.
Right.
I've bound you over to stand trial. I'm now going to conduct your arraignment regarding those proceedings. So I would advise you are before the court on a complaint that alleges that August 10th, 2024, at the location of 2201 Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan, that being the Washtenaw County Jail, that you did, being a person lawfully imprisoned in the jail, did assault a John Apple, who was an employee of a place of confinement or other custodian, knowing the person to be an employee or custodian, through either the use of violence, threats, violence, or dangerous weapons while you were awaiting trial, contrary to Michigan statutes. Do you understand what you are charged with, Mr. Jolly?
I understand what I was charged with, yes I do.
Okay, that is a felony. It is punishable by up to 5 years incarceration and a $250 or $2,500 fine plus court costs. You understand that, sir?
I understand that.
All right. I do also have to advise you that if you are convicted, law enforcement is to collect a DNA identification profile sample before sentencing or disposition if it was not taken at the time of arrest. You understand that, sir?
Yes, I do.
All right. How do you wish to plead to that charge, sir?
No, not guilty. I also.
All right. The defendant, having heard reading of the information, pleading not guilty, court will enter that plea. A pretrial in this matter will be set for
September 25th at 1:30 for Judge Slip.
September
25th.
September 25th, 2025, 1:30 before Judge Slay.
Okay, my request for jury trial, I requested a speedy trial already, and I did file these motions. Now, can you, is this where I bring this up again? A speedy trial.
You can bring those up before Judge Slay.
I've already requested it before you, though.
I know. And what
So,
I'm indicating is that I am not making a ruling on those because I don't have to. First of all, in regard to any delay in these proceedings, Mr. Jolly, you were the cause of the delay. So I think that any reference you're having towards speedy trial,
there's a right to speedy
is
trial.
really your issue.
There's a
Your
right
issue to a
speedy
trial by jury is intact. You will have your trial by jury if that's what you wish.
That's
Again, you may raise all of these issues before Judge Slay.
I did request a 12-person jury also.
In circuit court, that's the way it rolls.
And so that's the way it goes to the speedy trial. I don't have what you're saying. I don't have a right.
You can raise that if you think that you have been denied that. My ruling is that there has been no violation of any right you have to a speedy trial, because any delay that has occurred in these proceedings is either an acceptable delay in terms of the competency, but also any other delay was a result of your conduct.
It was 30
that
days
delayed
ago
these
on my
proceedings.
request, Your Honor.
Mr. Jolly, I'm not going to sit here and argue with you. I'm telling you what my ruling is. You may raise that issue again if you like before Judge Slay.
To
You
deny
will get your
the
jury
speedy trial,
trial.
is what you're
That
saying.
will all be set before Judge Slay, and you'll be able to proceed there.
So you're
At this
denying
time,
the right to
these
speedy
matters
trial.
having concluded, your bond is continued. Thank you.
Final analysis. What we saw today is a textbook sequence of how a single, credible eyewitness account inside a confined facility becomes sufficient for probable cause, especially where the victim is a corrections officer and medical follow-up corroborates the claim Mr. Jolly's decision to represent himself, mixed with competency and participation issues, complicated his procedural posture and limited his ability to challenge evidence technically. The court balanced defendant rights. You still have your jury trial right. Against practical realities, delays were partly attributable to the defendant, and the people met their burden at the preliminary stage. That's the practical takeaway for viewers. Courtroom outcomes ride on both facts and procedure. Now tell me, did the judge get this right? Should Mr. Jolly have a lawyer to navigate these motions? Drop your verdict in the comments. If this breakdown helped you understand probable cause hearings, do the channel a favor, hit like, share this video with someone who thinks court is just TV, and subscribe to Justice Desk for more no-nonsense courtroom breakdowns. We post sharp legal explainers and real case analysis. Join the conversation, and I'll see you in the next case.